Good morning and welcome to Circuit Court Jury Service. You're probably wondering, how do I come to be a juror in this county? Why is my name selected and others may not be? Let me answer that first by telling you that the state of Tennessee provides a database from driver's license to counties, and their computer system randomly selects citizens in those counties to update a current jury list for those who are eligible to serve. My name is Jim Gass, and as one of your circuit judges, I want to welcome you to jury service in this county. On behalf of my fellow judges, Carter Moore, Dwayne Sloan, and Rex Henry Ogle, we all appreciate your willingness to give your time and service to your county to help our system of justice function properly and work smoothly. Over the next several minutes, I intend to talk to you about some of the rules and procedures that will take place and you will apply in serving as a juror in this county. Let me begin by saying that to qualify as a juror, you must be at least 18 years of age and a resident of this county for the last 12 months. You also must be of sound mind, and you cannot have a disqualifying felony conviction on your record. And you do not have to serve as a juror. You can only serve every 2 years. So if you've served as a juror in the past 2 years, you would be disqualified from having to serve again right now. If you have a question in your mind about serving on a jury and your qualifications, please contact the circuit court clerk, and we will get an answer to those questions for you about your eligibility to serve. You know, it is truly an honor to live in this great country of ours. And having jury trials to decide disputes, either in criminal cases or in civil disputes between persons, is one of the great advantages of being a citizen. In my mind, other than the right and privilege to vote, one of the greatest honors of being a citizen is being able to participate in our system of justice through jury service. Again, thank you for your time and attention today. Let me begin by saying there are different kinds of trials as a juror that you may see. You may be asked to serve on a civil jury. That is a jury of persons that are asked to decide disputes of a civil nature where damages are decided. It might be over a contract dispute. It might be over a land dispute. It could be a car wreck where there's injuries. It could be some type of liability, even a wrongful death case, where the measure of relief is money damages. You may also be asked to serve on a criminal case. And in that situation, you'll be asked to decide, is the person accused of a crime guilty or not guilty? There is an additional service that some of you may be asked to spend time serving, and that is on a grand jury. I will talk about each of these in more depth. Let me begin by saying that if you're chosen for a grand jury service, you will be asked, and there will be 13 that serve on a grand jury at a time. You will be asked to consider whether someone who is arrested and has been before the general sessions judge and had their case bound to the grand jury should be sent to circuit court on formal criminal charges. The standard you'll be asked to employ is a standard of, after you review the evidence, is there probable cause to believe that the person accused of the crime by warrant or arrest is the person who committed a crime and was a crime committed. Is there a likelihood that this accused committed that crime, and enough so that the case should be presented to a jury for determination. Those 13 citizens will meet in secret. They will have the assistance of the District Attorney General. They will consider cases which are called bound-over cases to the grand jury from General Sessions Court. On some occasions, the grand jury will also consider cases which no arrest has yet been made, but instead there has been an undercover operation, an investigation which warrants criminal charges. And they will be a case of first impression with the grand jury you serve on. Again, as I previously said, you will be asked to consider a probable cause standard. Is the accused the person who committed a crime and was a crime committed? If the mind rests easily with that, then probable cause can be met by the state's showing of evidence at the grand jury. In Tennessee, a defendant does not testify in most circumstances at a grand jury. You will hear the state's case, the evidence most favorable to the state of Tennessee, and the district attorney will be available to assist in explaining the law in Tennessee about what the crime possibly is and the law that applies to that crime and any lesser included offenses. Witnesses will be called to the grand jury. They will be sworn by the grand jury foreman to tell the truth, and the grand jurors themselves will be able to ask questions of this witness or any other witnesses on the case that appear before them to gain insight into what the case is about and should a charge be made. Now, if the grand jury finds probable cause that this case should travel on to circuit court for a trial, they will issue an indictment, and the foreman of the grand jury will sign that as a true bill. And that will then be sent to the circuit judge, and the defendant will be arraigned in circuit court, and those proceedings will begin at that point. Those investigations which are presented directly to the grand jury will result in a presentment being sent, a true bill on a presentment being sent to the circuit court for further proceedings. If there is a presentment, all 13 grand jurors will sign the back of the presentment. When you take a vote as a grand jury to decide whether to issue a true bill or a no true bill, 12 of you must vote in favor of a true bill out of the 13. There is a basis for this. It does not have to be a unanimous decision. There is comfort in knowing that no one in the community, even if they know you serve on a grand jury, knows how you voted, because it is not unanimous. Grand jurors do have the capacity, if they are aware in their community of a crime, to call witnesses independently about that crime or criminal conduct and make some determinations, should a charge be levied. At the grand jury proceeding in the beginning, an overview of the rules applying to the grand jury by statute will be presented to you by the District Attorney General. The grand jury, once those remarks are made, will make a determination in private whether to have the assistance of the District Attorney General throughout this process for the entire day on all the cases. The District Attorney General, should you elect to have their assistance, as they know a great deal about the cases coming in, will not be present when you discuss it among yourselves and deliberate and vote to find probable cause and issue a true bill, or no probable cause and issue a no true bill. They will step out and allow you to conduct your business and then step back in, should you so elect, with the next case. I encourage you to consider the District Attorney General's assistance in explaining the law to you. It is not mandatory, but it may well, as you discuss it, be very helpful. As a grand juror, that is a secret proceeding. Your friends and neighbors and any other person is not allowed to ask you questions about what transpired or took place in the grand jury room. Those are all confidential and private proceedings. If someone contacts you or persists in wanting to know how others on the grand jury acted, or about cases that might still be sealed in which there is a true bill presentment, you're under no obligation to discuss that with anyone. Matter of fact, the law protects you from having to do that in Tennessee. And if that person persists in asking you, please contact the court or the clerk of the court. And that matter will be addressed so that you're not harassed or contacted any further. Now, let me give you an overview of how a case may come to you as a grand juror. Many times, someone is arrested in the community for a violation of the law. Their case will first go to the General Sessions Court on that arrest warrant. Generally, a bond will be set on that charge so the person will not have to sit in jail and await any further legal proceedings. The bond should be reasonable, and there is a very limited circumstance in Tennessee under the law where no bond is allowed. That is not necessary for you to worry about at this stage, but once that arraignment of the charge and a bond is set, there will be a preliminary hearing set in front of General Sessions Court on criminal cases. There will be a hearing of facts before the General Sessions judge, and that judge will make a probable cause finding themselves. If they find probable cause, they will bind the case over to the grand jury that I've just discussed. That grand jury will then again, as a constitutional safeguard, hear evidence about that case and witnesses, and be able to ask questions of those witnesses about facts in that case, and they too will make a finding: is there probable cause or is there no probable cause? Once that is done, the case then goes to circuit court if there is probable cause and a true bill is issued. In circuit court, the accused, many times referred to as the defendant, will be arraigned in front of one of the circuit judges, either myself or the other three that I've just spoken about. At that arraignment, it will be determined if they have a lawyer, if they're aware of the charges, and if they cannot afford a lawyer, one will be appointed to assist them in this legal process. And then scheduling of that criminal case and motion hearings and issues relative to the law will be scheduled before the circuit judge. Ultimately, if there is not a plea agreement in a criminal case and the state travels forward prosecuting that case, there will be a jury trial. I spoke to you earlier about civil cases and criminal cases. There will be a criminal trial where charges are brought from the grand jury. Let me talk about that first. If you're not on the grand jury, but rather requested to serve as a juror in a criminal case, the standard of proof, the burden of proof, let me begin by telling you, is always on the state of Tennessee. And the standard of proof the state must show to a criminal jury is proof beyond a reasonable doubt. That's a heavier burden under our law for good reason. The state has that burden, and the defendant, the accused, is presumed innocent. And that presumption stays with an accused person under our system of justice throughout every phase of the criminal proceedings. If there is a criminal trial, the only time that the presumption of innocence would ever go away is if a jury, after a trial, finds the defendant guilty of what they're accused of or some lesser included offense. Now, at that trial, the jury's verdict, your verdict as a juror, must be unanimous before anyone accused of a crime can be found guilty of a crime. And The standard is beyond a reasonable doubt. The judge will charge you at the end of a criminal trial with a set of jury charges. The judge will read them to you, and you will be given those charges, and if you're a juror, you will take those to the jury room and refresh your memory, look over them. It will have the law, and it will have your instructions on proceeding with deciding the case. But your verdict must be unanimous in order for anyone to be found guilty of a crime. For you to find a defendant not guilty of a crime, your verdict also must be unanimous. That means all 12 of you must agree they're not guilty, or all 12 of you must agree that they are guilty. In some circumstances, jurors are not able to unanimously agree. There may be one person that believes one way and 11 that believes another. There may be many that believe one way, more than that, and the rest believe another, but it's not unanimous. In that case, that is a hung jury. And if there is a hung jury, the court will deal with that, most likely by declaring a mistrial. And if a mistrial is declared, the state of Tennessee, through the District Attorney General's office, must decide whether they will prosecute this case at a new trial at a later date, or they will dismiss the charges. During the course of this trial, the accused, the defendant in a criminal case, does not have to offer any evidence. The accused does not have to testify, even at their own trial. That is a constitutional right we as citizens of this great country have. All of us have. And if you are accused of a crime, you never have to testify. And a jury may not consider that as any sign of guilt, because that's everyone's right not to. Now, after consulting with their lawyer, an accused might decide they want to testify. But remember, the burden of proof is on the state of Tennessee, and the state must prove their case, not with the defendant's testimony and the defendant's free not to testify. That burden is always on the state of Tennessee. During your deliberations, and this applies to both criminal trials and civil proceedings, civil trials, you are not allowed to discuss the case among yourself, if you're a juror, until all the evidence in the case has been testified to and brought before the court in open court, and you've heard everything. You may not discuss what you think about the certain witness or certain evidence in the case until the end of the trial, after the judge has given you instructions on your deliberations and instructions on what the law is you're to consider. You may talk about your neighbors, you may talk about your children, your grandchildren, the weather, and anything else among yourselves while you're waiting for this trial to conclude when you're not in the courtroom. But you may not talk about the case itself. During a criminal proceeding, there may be times that the judge brings lawyers up to the bench to talk about issues, and the judge might mute the microphone. Do not concern yourself with these proceedings. There are many legal issues and procedural rules that must be employed by the court and used by the lawyers that make the trial more efficient and move the trial along, but the court many times has to make those decisions and decide issues. And that is done at the bench often to prevent you as a juror from having the entire jury exit the courtroom, wait on the court to entertain the issue, and then bring you back in. Nothing that the judge says during the trial is intended at all to be evidence or instructions to you about one way or another about how you should vote. That is an independent decision that you will make when reading the instructions, applying the law that the court gives you, and deciding the case. Now, let me back up and tell you that if you are selected to be a juror, both in a criminal case and in a civil case, you will be a prospective juror until you're sworn to serve as a group as a juror. You may be asked to come forward and take a seat near the front of the courtroom in what we commonly call a jury box. When those things occur, lawyers, after we get 12 citizens gathered as prospective jurors, will be allowed to ask you questions. Now, I can assure you that I will not allow, and I know my fellow judges will not allow, inappropriate or deeply personal questions that might tend to embarrass or offend you. This is not like a television show. We will employ rules that allow lawyers to ask questions relative to the case that is to be decided. And lawyers will ask some questions, and individually at that time in choosing jurors. That is to help them make an educated guess as to who they believe would be the fairest juror to serve in that particular case. Do not be offended if you're excused from service on that given day. For the next time you come, the lawyers, whoever they may believe that you're the best juror that could possibly serve in that kind of case. Lawyers are given a certain number of challenges, both in criminal and in civil cases, that they may exercise without cause, meaning that because they believe or have a feeling that a particular juror wouldn't be the best to serve on that particular case, they may excuse that particular juror. And that is simply part of the process we employ in our jury selection. Now, you will not be asked to serve on a case where you're related to one of the parties in the case, or that you have some knowledge of the case, unique knowledge where you potentially yourself could be a witness, and you will be given a chance to raise your hand, talk about those things. The court will ask preliminary questions about the case. For instance, you might well be involved in some legal matter that one of the lawyers in the case is representing you, or that lawyer might be on the other side of a matter. And you may have feelings about that particular situation that could override your ability to fairly and impartially judge a case, that particular case. And that should be brought to the court's attention during this jury selection process. And if something's on your mind that the lawyer hadn't gotten to, but you want the court to know, simply raise your hand. The judge will recognize you. And if it's something that is of a personal nature that you don't want to share with everyone in the courtroom, the court will allow you to approach the bench and advise the court as to what the issue is. A good example of that may well be if you are chosen to be a prospective juror in an abuse case or a sexual crime case against a child, and you or your family has had someone related to you that's been a victim of that type of crime, or that someone in your family has been falsely accused of that type of crime, and sitting in judgment on an unrelated case would cause you mental anguish or would be too uncomfortable for you to be a fair and impartial juror, those are the appropriate times to bring that to the court's attention and let the court decide if it's appropriate for you to be excused. Now, once 12 citizens are chosen to serve on a jury, either in a criminal case or a civil case, there will be one or two other persons chosen to serve in an alternate capacity. In the event during the course of a trial we have a juror fall ill, or we have something come up that would disqualify a juror, then the trial can proceed on with the others remaining. In the end, ultimately, only 12 will decide the case, and any others that we have termed alternates will be excused at the conclusion of all the trial before you as a juror, all 12 go to deliberate on the case. When you deliberate, follow the instructions given by the court, follow the law given by the court. Use your common sense, and I've heard that over my entire legal career in talking to jurors. And that's the best way I can describe how one should view the evidence and the facts in a case. You judge people every day of your lives. No one asks you to set aside common sense when you come to serve as a juror. Now, during a trial, you'll hear remarks from lawyers, either in a criminal or a civil case. There will be opening statements, usually opening remarks, which are a presentation by the lawyers on what you might expect in serving as a juror in that particular case. You might expect to hear what the evidence they believe will show you. At the conclusion of all the evidence, the lawyers will be given an opportunity to make closing remarks. And that will be a summary of what they believe the evidence has shown you and how the law applies to that evidence before you reach a decision. Remember, those remarks, both at the start of the case and at the closing of the case by the lawyers, is not evidence. They are intended to be an outline or overview of what you would expect or what you have heard for you to consider, but it is not evidence. The court will give you the law to apply to the evidence that you have heard at the trial come in from the witness stand. I've talked to you at length about criminal trials. You will also be impaneled potentially to serve as a civil juror. I told you in a criminal trial, the burden of proof is on the state of Tennessee, and the standard of proof they must show is proof beyond a reasonable doubt. Now, that's a much heavier burden of proof than in civil cases. And the reason for that is because someone's liberty is in question to be decided by a jury in a criminal case. In a civil case, usually the standard is by a preponderance of the evidence. It's a different standard, a lesser standard. And a good way to imagine that standard or understand it is to think for a moment that you have a scale on each side. One side for the plaintiff or the party who has brought the lawsuit, and one side for the defendant or the party being the lawsuit is brought against. You place the evidence you hear in the courtroom on that scale, and if it tips in favor of one side or the other, then that is how you would find by a preponderance of the evidence. Whose side does the evidence favor? Still, in civil cases, you will take instructions from the court and what the law is from the court and apply those to the facts that you have heard from the witness stand. Let me ease your mind about a couple of things. Although the court has a calendar scheduled for jury trial days, many cases, especially civil cases, resolve before they get to trial. People reach a resolution of their own accord, and both sides agree on a settlement. In criminal cases, many people may work with the District Attorney General's office through their lawyer and reach some type of plea agreement. So there will be days that are potential jury days you will not have to come and serve. What will occur is that the clerk will have a telephone line for you to call the day before, the evening before, and you will determine then whether or not you will be needed on a given day or days to come in and serve as a juror. Again, bear in mind that many of those days you will not be asked to because the cases are resolved. Also remember that in this time of virus outbreak and sickness, this court, and I speak for all my fellow judges by saying we are keenly aware of social distancing and safety measures which we must employ to ensure that should you be called to serve as a juror, we will provide the safest environment we can possibly provide for you. Our Supreme Court has mandated, and we employ those mandates, that everyone in a courtroom will wear a mask when there for a proceeding. Everyone will social distance during those proceedings, a safe distance in accordance with health standards. We take that very seriously, and we take your safety and health very seriously. And we will work and continue to work to make sure that your service to your community is as safe as it possibly can be. I have gone over a few of the highlights that you can expect to see when you serve as a juror. If you have questions about your service, do not hesitate to contact your circuit court clerk. They will get you an answer. It may be that you have a medical procedure that cannot be avoided. It may be that you have some particular day that is of terrible conflict. Let the clerk know about those issues. We greatly appreciate your service to your community. I look forward to seeing you serve as a juror in my court, and I am certain my fellow judges look forward to seeing you serve as jurors in their court. Thank you for your time and attention today, and again, welcome to Circuit Court Jury Service.